Today we're diving into the criminal proceedings. Criminal proceedings based again on because there's a legal protection of everyone because the Constitution applies to everyone. And there's the principle of legality, there's a presumption of innocence, and they all play an important role in the protection of the suspect against the government, which of course has more means than the suspect will ever have. So to make sure that the suspect is protected in his rights, he has the right to a lawyer, and this can even be paid for by the government, subsidized by the government when we talk about pro bono lawyer. This actually means that he does it for God, but he gets paid by the government. Just to make sure that the rights of all suspects are protected at every time. This applies in the case of the whole criminal proceeding, the investigation against a suspect. This is all laid down in het strafprocesrecht. And this protects the rights of the citizens in the case of an investigation. Again, to protect it against the abuse of power or the misbehavior of the whole judicial system. So this means that the police does have certain means of coercion, but it needs extra permission to do specific types of investigation, of research. For this, it needs to go to a public prosecutor who is leading the whole investigation anyway. So the police does not make its choice alone. It's a public prosecutor, or in certain cases, it has to go to an examining judge which has to weigh whether or not the measure that the police wants to take fits with the whole investigation and with the rise of suspicion against the suspect. So for in case if they want to tap a phone, they need to go to an examining judge to get permission, because it is a violation of your right on privacy, which is laid down in our Constitution. So things that they will have to go to the prosecutor for are to get a warranty to enter a house or to do a house search. And in this warrant, not warranty, sorry, warrant, in this warrant, it must be clearly stated what they are searching for. Meaning that if they find anything which was not stated in the warrant, it cannot be used in the whole trial. Well, just talked about the phone, and also infiltration. You will need an examining judge to do so. If the investigation leads to the suspect also has rights. There are rules on the period of detention, on pre-trial detention, which apply to every suspect. The first time you cannot be detained more than 6 hours before the prosecutor decides whether or not you will be detained again, or longer. And then he can prolong it for 3 days, and again 3 days, and then he needs to go up. So it must be known what you're detained for. The time is limited, and then it goes to an examining judge who prolongs the imprisonment, or gives permission to prolong the imprisonment. And then if it takes any longer than 110 days, that's the max, there is a pro forma hearing, in which it is mostly looked at whether there's enough basis to keep this suspect detained. But in general, they will try to come to trial quicker. And most people are certainly not longer than a year in pre-trial detention. They want to come to a good case as quick as possible. Then, if it comes to prosecution and trial, it is determined actually by the prosecutor, who has three options after the investigation. First of all, dismiss a case. When there's a lack of evidence, or when the pre-trial detention has already taken so long, or maybe even if attention of the media on a specific case has already damaged the person so far that they believe that the punishment has been big enough, the prosecutor will dismiss a case. They will not bring it to trial. And then a person is let off free. There's another way not to come to trial, and that's with a settlement. In a settlement, there is enough evidence to come to court, but the whole case is resolved between the prosecutor and the lawyer of the suspect. And then someone gets a fine or maybe a community service, but there will not be a trial. And then, and this actually happens in the least of all cases, the prosecutor can decide to go to trial and bring the suspect with its evidence in front of a judge. This is always at first the district court. And that's the court in the district where the offense has been done. And they can be visited, by the way. So they're always open trials. At least mostly they are open trials. Sometimes they're closed, considering the urge of the trial. And with minors, of course, they are closed. So after this trial, it's up to the judge, an independent judge, to pass a verdict. And when he comes with a whatever verdict, both prosecutor and the defendant can decide to go for appeal, which means they go to a higher court, the Court of Appeal, het Hoge Rechtshof, where the whole case will be tried again. Does that mean that at the end of this trial it comes to an end? Well, no. But that's the last time that the case will be tried. If another appeal is made, they can go to the Court of Cassation, the Supreme Court, het Hof van Cassatie. And this one does not try the whole case again, but it looks whether the law has been applied accordingly. So if there are no mistakes, if no mistakes have been made throughout either the dealing in the district court or in the Court of Appeal, and if they come to a ruling, this ruling is binding. You have no other case of appeal. And after that, well, the punishment is implemented, which can be probation, can be a tax off as well. It can be imprisonment, but all options are open. But we will look into that in a later lesson, and also whether the whole punishment ID does serve a purpose. Toodles!